Thanks for taking your time to come and listen to me as well. My name is Luca Egitto. I am an IP and technology lawyer from Italy. I am one of the founding members of ILAAI, thanks to Vincent and his outstanding work. I also am a research fellow at the Information Society Law Center at the University of Milano. And I'm a shareholder and an advisory board member of a legal tech company in Italy that leverages generative AI. I think that this context is excellent to discuss a key issue on protecting AI-generated content. There's a lot of debate, and the main question is, who owns the copyright in the output? But does the output qualify for copyright? That's the key question. Obviously, this was largely discussed among scholars, practitioners, lawyers, judges. Always an interesting discussion, but you need something to stabilize the discussion. Normally, this comes from courts or the legislators, and this is exactly what happened, at least in Italy. We will have a small journey that starts from Italy and goes to France and then Canada. You will listen later from Stéphane, Philippe, and Vincent, all their angles. And this is what happens in Italy. But the discussion is, does AI-generated content qualify for copyright? You will see at the end of the slides that Italy's Article 1 of copyright law did not specify at the outset that the author should have been a human being. It was implied. It was not necessary to specify this. It was in 1941. Only human beings were conceived as authors. But now we have machines that can generate really smart stuff. Do we need to adopt laws to cover AI-generated work? Some jurisdictions have legislation to cover computer-generated stuff. Italy does not. And should we amend the laws in general to make them compatible with AI, with this new environment? Actually, this already happened. We have an AI Act in Europe, and you will see that Italy is actually working on a draft law on AI. I'm not saying it is necessary, but the government apparently is of this opinion. So the case and the matter of the next slide is very glamorous nowadays, is of greater relevance because it concerns the Sanremo Festival, which is Italy's most famous musical event, which is taking place today and gathers huge attention. And I would say that half of the population of Italy is watching TV on these nights. So a lot of focus is on the stage. And what happened triggered litigation between the broadcaster, which normally displays on TV this show, and the alleged and self-declared author of this work. But why is it relevant? Because it changes the way that the Supreme Court approaches the concept that gives rise to protection, which is creativity. Historically, courts have been very generous in awarding and recognizing copyright protection to authors. It was not considered required to have absolute originality or absolute novelty or outstanding value. It was not necessary. Courts were happy if the author was giving his own personal imprint, his intimate manner to express, the way he perceives the world. Even simple and banal concepts would be protected if they reflected the personality of the author. But Supreme Court, in this case, had to adapt his reasoning for the first time for computer-generated and AI-generated images. So in the next slides, I think that we could see what was the subject matter of discussion. So the broadcaster, apparently, and I wouldn't be surprised if they behaved so recklessly, found on the internet some nice images, fractals and flowers. Say, okay, let's use them. They put them on the massive stage. and half of the population admired this really nice digital content, including the author. She took action, and we can go to the next slide and see that she won the first and the second round. So the first instance court recognized protection, also the Court of Appeal, and then the broadcaster further appealed to the Supreme Court. What the broadcaster did was a mismanagement of procedure. So the Supreme Court said they would reject the appeal for procedural aspect, but they addressed the issue, although in a very high-level manner. The Supreme Court says the fact that you're using AI does not rule out authorship. You can still have authorship. But the key aspect is if you use an AI software, you can qualify for copyright protection, but you need to demonstrate that there's a sufficient degree of creativity in the input, in governing the process. It is true that a machine gave rise to the content, but actually there's still a human being that operated the prompt, that gave the instruction. If you find some imprinting of this, then you find authorship. So there is an interesting reading in an interpretation of this decision. So the traditional criteria adopted by case law to find this requirement of creativity now should be adapted. And they can apply even when the creative process, in part, is operated by an artificial agent, provided that the algorithmic processing constitutes the continuation of an impulse and choices made by the human agent. So this is the interesting interpretation of the connection between human and algorithms. So there should be a connection, and there should be some visible imprinting. And now if we go, again, 2 slides onwards, you will see that the Italian government took inspiration, probably, from this decision and proposed in the draft law a small but very impactful change. As you can see, Article 1 initially didn't contain the term human. It was 41, obviously. There must have been some human beings doing that stuff. But they made this clarification because they also added something at the end of it, which is kind of groundbreaking, if approved. They stating now that intellectual human works of creative nature belonging to literature, music, figurative arts, architecture, theater, and cinematography, whatever the mode or form of expression, also were created with the help of AI, as long as the human contribution is creative, relevant, and can be demonstrated, are protected under copyright. This is potentially groundbreaking. But then the issue will be, how do we assess human contribution? This will be the main shift of courts and scholars. But, you see, even those sometimes backward and very reluctant to innovation lawyers and legal practitioners can have a decent view on the future. And I think this is something that will occur also in other jurisdictions. So thanks for your time, and I'll recommend that you also listen to the angles from France, Canada, US that Vincent, Philippe, and Stefan will give you later on. Thanks again for taking your time to listen.